Many of you may be surprised to learn that some of the largest and most impactful legal decisions in Jamaica are not decided in a court of law. They aren't even decided by appointed judges. That's because many large companies have opted to have their contractual disputes resolved using an alternative option to the Jamaican courts, and that option is called arbitration. Now, the law concerning arbitration was revised in 2017, and since then, corporate Jamaica has seen an influx of arbitration cases where trained and appointed members of the public get to sit in a judicial chair to decide cases that may have massive consequences for those companies. We're joined by Trudy-Ann Dixon Frith, partner and the co-head of the Litigation Department at DunnCox Attorneys-at-Law. Good afternoon, Trudy-Ann.
Good afternoon.
Welcome to Home Run, and your legal landscape is on. First of all,
thank you for having me.
Oh, it's always a pleasure. Love the information. First of all, let me ask us to clarify, what is arbitration?
Okay, so the parties to a contract may mutually decide to have their disputes resolved by way of arbitration rather than pursuing a civil case in the parish court, for example, or the Supreme Court of Jamaica. So in sum, arbitrations allow disputes to be resolved that has a binding effect by persons. It could be one arbitrator or a number of arbitrators, for example, 3, acting in a judicial manner. It is done in private rather than in a court of law that would have jurisdiction, but the parties have agreed to exclude the court of law. And so the person that hears the arbitration is called the arbitrator.
Okay. Then why should people choose arbitration?
So arbitration is preferable, a lot of parties find, over litigation because it is less expensive, it is quicker than going to court, it is more secure, it offers more privacy and confidentiality to the parties. The matters between the parties may also require very specialized expertise to determine whether one of the parties is liable under the contract, for example. And what arbitration allows is for a greater level of expertise as compared to a judge, because an arbitrator can be appointed from a group of professionals who have specialized knowledge of a particular trade or business. And so a lot of parties prefer this because it boosts their confidence and trust in businessmen in the proceedings and any resulting award or decision that may be made by the arbitrator.
Makes sense. Trudy-Ann Dixon Frith is partner and the co-head of the Litigation Department at DunnCox Attorneys-at-Law. Let's ask, Trudy-Ann, when do you choose arbitration as being the method of resolving disputes?
So the parties choose arbitration at the time when they are negotiating the terms of their contract. And it is at that time that a clause for arbitration should be included. And the standard arbitration clauses are quite wide, and it should really include any issue arising from interpretation, application, breach of the agreement, enforcement of the agreement, performance of the agreement. The clause should really encapsulate that, to say all of that is to be settled by arbitration. The other thing that it is recommended that the clause has is the method of choosing the arbitrator should be agreed between the parties. Mm-hmm. So, for example, within the Caribbean context, the parties can agree that arbitration be administered by, for example, the Arbitrator Conflict Resolution Service, which is in St. Kitts and Nevis. There are 3 other things that must be included in an arbitration clause for it to work. And one is the rules which will govern the arbitration proceedings. So again, for the Sentits rules, it's called the ACRS's Expedited Arbitration Rules, for example. Secondly, the law of the jurisdiction which will be applied in the arbitration proceedings must be included. So you would have a clause that says, for example, the laws of Jamaica will apply to these proceedings. And you're also to agree where the seat of the arbitration will be. And that can get complicated because the parties, for example, can be in America, but decide that the seat of arbitration will be in Jamaica, for example. Mm-hmm. And the seat of arbitration just simply means which country will the arbitration be held or be deemed to be held. And lastly, for there to be an effective arbitration clause.
I'm sorry, can you repeat that? There to be what?
Sorry. For there to be effective arbitration.
For some reason, there's just been a popping as you're to say those all-important words as to describe the clause.
Are you hearing me now?
Yes, let's see if we hear it now.
Yes, let me repeat. I was saying that for there to be effective arbitration clause, the award of must provide that award of...
Trudy, I'm going to ask you to hang up and we're going to call you again because I want for listeners to be able to listen and hear each of the words and to have the breakdown of what the clause is that we're actually talking about. So we're talking about the arbitration exercise and giving you the breakdown of the various aspects of arbitration and how you may want to use that means of deciding a conflict that you have with someone instead of going through to the courts. So the option that we're talking about is arbitration, and Trudy-Ann Dixon Frith is partner and the co-head of the Litigation Department at DunnCox Attorneys-at-Law. She is breaking down the details for us of arbitration and helping us to see how it is that you may want to have this form of resolving disputes used instead of walking through the court of law. It's a more personal exercise, we're told. You both get to choose, who you want to sit down and have this discussion with. So I think it's a timely exercise that we have this program at this point in time for us to sit down and hear this form, arbitration. Could it be something that you may want to use, a suitable alternative to litigation? I certainly hope so. So arbitration is the word, and we will be speaking with Trudy-Ann Dixon Frith. Again, she is partner and co-head of the Litigation Department at DunnCox Attorneys-at-Law. So, Trudy-Ann,
yes.
We're here inside Home Run. We're here inside the legal landscape. It's so important for us to be keenly aware of the options that we have ahead of us. And you're telling us about the powers of the arbitrator.
Yes. Well, prior to me coming off, my last point was to say that for there to be an effective arbitration clause, it must be included in the contract that the award of the arbitrator will be final and binding. Otherwise, it's not going to make sense. It's not going to work. It's an unworkable clause.
Yeah. So once you make this decision, you're going to work with this decision.
Exactly.
That's the agreement.
Exactly.
All right. So what are the powers of the arbitrator?
In terms of the powers of the arbitrator, it's wide and varied. Very similar to a judge, though not the same. So they can make determinations, for example, that they have jurisdiction over a matter in dispute. Indeed, some matters cannot be arbitrated. For example, if a party wants an injunction, that cannot be granted by the arbitrator. But an arbitrator can also make interim orders, example, to preserve the assets in dispute between the parties until the final determination of the matter. Mm-hmm. An arbitrator can also make orders as to how the arbitration proceedings will be conducted. For example, will the evidence of witnesses be taken in a written format? Will cross-examination be allowed? all that the arbitrator can decide. He ultimately can make a final determination of the dispute between the parties in accordance with the law. So he actually considers applicable laws and apply them. And he can award compensation if the circumstances warrant it. And lastly, he can also apportion cost of the proceedings between the parties.
Okay, so it is quite detailed. I'd like you to tell me two things: how the arbitrator is selected and the costs of the arbitration, which should be contemplated by the parties.
Yes, so in terms of how the arbitrators are selected, ideally you also want to put that in the contract as to it is supposed to be by agreement between the parties, and a mechanism is inserted in the contract for the parties to agree to that mediator. In terms of costs to be contemplated by the parties, that includes the cost of the arbitrator that is usually borne jointly by the parties. You have to consider, well, definitely depending on the complexity of the matter, the attorney's cost of the proceedings, and these costs are usually recoverable at the end of the proceedings by the successful party. And there can be other costs, such as if your matter requires expert witnesses to come and give evidence, you would have to pay those expert witnesses. And one very interesting point is that under Jamaican law, an arbitrator does not have to hand down his decision until all his fees are paid.
I say nothing there. But if you really want the decision, you pay up. If you disagree with the award or with the decision of the arbitrator, can it be challenged in court?
Yes, but it's on very, very limited grounds under our Arbitration Act of 2017. And some of these grounds include, for example, breach of public policy. So, for example, where due process was not followed by the arbitrator in allowing each party to present its case, then the court will intervene. A second ground is that the arbitrator did not make any decision on the core issues in dispute between the parties. A further ground could be also that the matter which went to arbitration is not capable of being resolved in arbitration, such as if you allege that a criminal conduct has been committed. And lastly, and these are not all the grounds, these are just some, the arbitrator handed down decision on matters which went beyond the scope of the parties' submission to arbitration. Now, when you read the whole scope of the act, and it's relatively new and it's still being explored by persons, businessmen, but the whole policy of the act is that where the parties have agreed to arbitration being final and binding between the parties, then the court will uphold this agreement and it will not lightly interfere with the decision of the arbitrator. Because the entire point of arbitration is not to go to court.
It's not to go to court.
Yes.
All right, so you've heard it here. Arbitration on the Edge 105.1, 105.3. Do you have a quick hashtag, did you know, before we go?
Yes, I do. And it is within the Caribbean context, Jamaica is actually one of the leading jurisdictions for the holding of hearings in arbitration. There are arbitrations where the parties are non-Jamaicans. The issues in dispute arise outside of Jamaica, and yet the parties agree that the arbitration proceedings are to be held in Jamaica. And that's a lucrative, I think, and a developing and an emerging area that we can continue to build on as a nation, become an even more international hub for arbitration.
Well, thank you so very much for taking the time to describe this for us. Trudy-Ann Dixon Frith is partner and the co-head of the Litigation Department at DunnCox Attorneys-at-Law. Our topic today, arbitration, a suitable alternative to litigation. Trudy-Ann, thank you.
Thank you so much for having me.
See you next week. This is The Edge, 105.1, 105.3 FM.